May it please the Court, my name is Avery Worley, and my co-counsel just discussed why the Stored Communications Act is relevant in today's case. I will be addressing why the Court should consider the third-party doctrine in today's case. Your Honor, the issue at hand is the accusation of a warrantless search and seizure under the Fourth Amendment. Tim Carpenter claimed that cell phone site location data should not be allowed to be a factor in his prosecution, granting it was a violation of his Fourth Amendment rights. Although, as I recall, they didn't search the petitioner at all. They got information from the phone company, which did not complain and gave consent. There was no search of Mr. Carpenter whatsoever. The correct legal definition of a search means examination of a person's body, property, or other area which the person would reasonably be expected to consider as private property by an officer for finding evidence of a crime. According to that definition, the FBI actually did not search the petitioner. Carpenter had no possession of the records, making it invalid for a reasonable expectation of privacy. The only thing that could be considered a search is when the FBI got information from the phone company about the petitioner. Even then, the phone company gave consent, eliminating the chance of a search or seizure. Without a search or seizure, there was no violation of the petitioner's Fourth Amendment rights.
Counselor, are you saying that Mr. Carpenter had no property interest in his location data? And if so, how? Why?
He had no reasonable expectation of privacy because when he gave up his information to be registered in the phone carrier's accounts, he gave it up to their possession and not his. Even if the government obtained the records from Carpenter directly, it would still be considered a violation of the Fourth Amendment. The third-party doctrine was actually designed to only grant privacy to information you wish to hide from others. You must obtain the subjective expectation of privacy in order to have those Fourth Amendment rights. A key implication of the third party is that the government only has to deal with the constitutional rights of the person or company that obtained and now possesses the information. Upon the receipt, the sender of the information no longer has Fourth Amendment rights. If a criminal gives up his crimes to his friend and the friend informs the government, it does not overstep the criminal's rights because once he handed it over to his friend, he lost possession of the information, resulting in a lack of reasonable expectation of privacy.
Counselor, studies have shown that many Americans are not aware of the fact that cellular activity can be used to determine your location. Should this fact impact the Supreme Court's evaluation of whether there is a reasonable expectation of privacy in cell phone location data?
No, Your Honor.
Why not?
Well, because the police didn't search any physical property belonging to Carpenter. So, when the petitioner gave up his information to his accomplices, the information was no longer in possession of him. If no possession was obtained from Carpenter without a warrant, then it wasn't a search or seizure. In the case United States v. Davis, a similar situation occurred. Davis, on trial with 5 co-defendants, was convicted on several counts of Hobbs Act robbery, conspiracy, and possession of a firearm in a crime of violence and sentenced to over 161 years in prison. He appealed on several grounds, principally arguing that the court admitted stored cell site location information obtained without a warrant in violation of his Fourth Amendment rights. The government overruled his claim as the only way it could be a search or seizure is if it was in the petitioner's possession, seeing as it was not because he gave the information voluntarily when signing up for the carrier. There is no violation of his Fourth Amendment rights. Another related case is Smith v. Maryland. Prior to her robbery, Patricia McDone gave the police a description of the robber and of a 1975 Monte Carlo automobile she had observed near the scene of the crime. After the robbery, McDone began receiving threatening phone calls from the robber. On one occasion, the caller asked that she step out of her front porch. She did so and saw the 1975 Monte Carlo she had earlier described to the police moving slowly past her home. Later, police spotted a man who met McDone's description driving a 1975 Monte Carlo in her neighborhood. By tracing the license plate, police learned that the car was registered in the name of the petitioner, Michael Lee Smith. The next day, the phone carrier provider set up a PIN register to record the dial numbers made by the suspect's phone, revealing it was Smith carrying out the crime. They were then able to obtain a warrant to search Smith's house. On trial, the petitioner sought to remove all evidence from the pen register, stating it violated his Fourth Amendment rights. The Court of Appeals affirmed the judgment of conviction, saying that there is no constitutionality protected reasonable expectation of privacy in the numbers dialed into a telephone system, and hence no search within the Fourth Amendment is implicated by the use of a PIN register installed at the central offices of the telephone company. Because Smith gave this information to the carrier upon signing up for the phone plan, all his reasonable expectation of privacy was suspended and given up to the third party, in this case, the phone company. In conclusion, no search or seizure took place upon Carpenter in no violation of his Fourth Amendment rights based on the Stored Communications Act and the third-party doctrine. In light of these arguments, we pray that the court uphold the lower court decision and let the police officers do their job and keep us safe by ruling in favor of the respondent, the United States, in today's case.